Funding clause 22, which provides funding through the services cost of election, was amended. Audit of accounts clause 25 of the Nigerian Revenue Service Establishment Bill 2025 provides that the accounts of the service must be audited not later after the end of the preceding year. Timeline too long, as the report will be required for planning and consolidation. So that was also considered. Findings of the Nigerian bill change distribution formula. Proposed tax bill 6 to change the horizontal VAT distribution. Derivation was also taken care of. There is no interpretation in the definition of the term derivation in the clause. The Nigerian Tax Administration Bill, that was also considered, a definition was given to it. Use of the term is ambiguous and susceptible to and possible challenges at the stage of implementation. Harmonization of the offenses, penalties, Tax Administration Bill was also harmonized. Clause 1 to register, 101 failure to file returns, 102 failure to keep books, 107 failure to remit tax deducted as source or self-account were also amended. Clause 104, 108, 121, 122, which deals with failure of fiscalization, non-compliance of virtual asset services providers like the cryptocurrencies, which today technology have taken over, false claim of tax refund and false fictitious have also been taken care on how the refund should be done. Findings of the Nigerian tax bill, development levy was considered. The bill introduced a 4% development levy to replace earmarked laws, primary acts that are there, like tertiary institutions, Education Fund, National Information Technology, National Agency for Engineering Infrastructure, and the others were all considered. VAT rates, we decided to maintain the 7.5% as proposed. The Senate Health Committee, we decided to maintain that. The excise duty, which of course had created a lot of issues, we considered it that as a signatory to so many customs treaties. What we did for clause 157 of the Nigerian tax bill, we introduced taxes, duties on service charges. We assigned the collection to the Nigerian Revenue Service. This will now give the customs their right excise duties, but the collection of service charges, service levies, and surcharges will be done by the Nigerian Revenue Service. The Petroleum Industry Act, some of the sections of that act have been taken, and the important with physical provisions into the Nigerian tax bill. Royalty on petroleum profit tax, PPT, and deep offshore island basin production sharing contracts is now under the administrative jurisdiction of the proposed Nigerian Revenue Service. It is important to note that this does not affect the entire provision, as other provisions remain valid and extant. The provisions of PIA that are proposed for amendment, which we looked at, are the Petroleum Industry Act number 6, 2021, as is amending by deleting part 1 to 6 chapter.
Yes. Just a minute. Your microphone.
Mr. President, by distinguished colleagues, I rise pursuant to Order 8 sub 3 of our rules to move for an extension of who will sit beyond. I so move, Mr. President.
The minority leader.
Thank you, Mr. President. Distinguished colleagues. Motion moved by the Senate leader that will extend our time to complete the assignment. I so second.
Thank you. Distinguished colleagues, the motion has moved and seconded that we do extend our sitting time beyond 3 p.m. Those in support of the motion say aye. Those against say nay. The ayes have it. Time is hereby extended. Yes, Chairman.
Thank you. I will just go straight to the recommendations. The committee made the following recommendations. Recommendation on the Joint Revenue Board Establishment Bill 2025, SB 5. The new insertion in Clause 25 is as follows. The Tax Appeal Tribunal shall be funded through the Consolidated Revenue Fund, as may be appropriated by the National Assembly towards the execution of its functions. Clause 26 provides structured and professional qualification standards promoting efficiency and credibility in tax disputes. Clause 30, jurisdiction of the tribunal. The Act expands the jurisdiction to cover all federal and state tax laws and to amend to restrict only to tax disputes and not controversies. The committee amended Clause 31. Tax appeal commissioners shall be paid salaries and allowances to be determined by the Revenue Mobilization and Physical Commission. Committee also recommended Clause 44, that is to create the office of the Tax Ombudsman, who shall be funded from the Consolidated Revenue Fund, as may be appropriated by the National Assembly. This is being done into providing funds for operation. Committee to also recommend 3% to be approved as of collection for the Nigerian Revenue Services. The committee amended Clause 51 as follows, except as I go back to the 3% because before it was 4%, which does not include the was non-oil revenue. But with the amendment that has been done, the Clause 51, except otherwise provided under this Act, any other law, agreement or arrangement as otherwise authorized by the board of or the executive secretary, any person who discloses institutional information, communication, document, or internal conviction, he is going to be vision or a fine to the tune of 5 million. Recommendation on revenue service. The objective of the bill should be amended, which we did, to provide for legal, institutional, and regulatory framework for the administration of taxes and revenue, accruable to government of the Federation as prescribed by the National Assembly. What we did, we amended Clause 5. Functions of the revenue service should be amended as follows. Assessed persons, including corporations, companies, and individuals, be in collaboration with the relevant ministries and agencies, subject to the approval of the Senate, review the tax regimes and promote use of taxation to develop, stimulate, and the growth of economic activities. Adopt measures to identify, trace, freeze, confiscate, or seize proceeds of tax fraud and evasion in line with the provisions of this bill and in line with international best practices. Clause 7 of the Revenue Service Act should be amended also. Seek to amend the chairman of the board we seek to amend that there should be a chairman of the board who shall be either the president or someone appointed by the president. So now deliberated at our closed session, and we all agreed that we should have Mr. President to appoint a chairman for the board who is a non-executive chairman. There will be executive vice chairman who shall be the head of the revenue and subject to the confirmation of the Senate. Clause 13.2 of the Establishment Bill 2025 should be amended that the secretary shall be a lawyer or a chartered accountant or a chartered secretary who shall not be less than the rank of a deputy director. Executive directors should be appointed by the president to the board. Suppose that the relevant clause should be amended that the president shall appoint executive directors for the service, each representing a geopolitical zone on rotational basis among the states in the zone, alphabetically or otherwise, depending on what Senate has agreed. And an executive director shall not come from the same state chairman and an executive director who will be heading one of the directing directorates. The timeline of reporting was also reduced from 6 to 3 months after the end of the year. Recommendation on the tax administration bill, which is one of the areas that have generated a lot of controversies. We have addressed that, and what we did with that recommendation is that the federal government will be 10% from the VAT. We did not amend the present VAT structure. We left it at 7.5% instead of increasing it as was recommended. So in that structure, we said 10% collection will be for the federal government, 55% of that collection will go to the state government and the federal capital territory, and 35% to the local governments. VAT revenue standing in the credit of states and local governments shall be distributed among them on the following basis. We recommended that A, state governments will have one, equality, which will carry 50% of that, population carry 20% with that, and place of consumption carry 30%. This is something that we deliberated with stakeholders, with the forum of subnational governments, that's the forum of governors. We have discussed this with ULAM, everyone, and we agreed. The only area that we also felt is necessary to address was how the local government's own will be shared. And on the local government, we said they share it among the local governments on equality, and then on their population 30%, and we stop there. Then we now change the word derivation to the place of consumption, which is the best, because every VAT is a product of consumption. So we now said derivation to be replaced with consumption, place of consumption, to provide clarity. And we also provide for penalties for the following offenses, which are like clause 100, failure to register. Fail to register for VAT when you're supposed to have services and pay those VATs. They said 100. You will see it is there in the bill. All the clauses that have been touched. Another area is in the Nigerian Tax Bill 586. The red is on the development levy. We retain the funding of TED Fund, NASENI, NIDA, and NEL Fund, and also we now brought the cyber security, because today, if you see how people are losing their money through the use of technology, we felt it's necessary to bring this to fore. And what we did with the development levy is that the tertiary education fund will now have 50%. The Nigerian Education Loan Fund will have 15%. National Information Technology Development Fund will have 10%. National Agency for Science and Engineering Infrastructure will have 10%. National Cyber Security Funds will have 5%. And Defense Security, because we felt it necessary that the security of this country cannot be, and hence, with the wisdom of Mr. President, we felt it's necessary to include defense security funds for 10%. We retained the VAT at 7.5. Company income tax, we didn't reduce it, and we didn't increase it. We left it at 30%. Clause 157 to 16, which is duty, which I have said earlier, we have deleted it. The provisions of BIA remained. They are excellent laws. So those areas that we deleted, I have mentioned. That the Senate, thereby having carefully considered the above, the committee hereby recommends as follows: that the Senate do pass the following bills: Joint Revenue Board Establishment Bill 2025, Nigerian Revenue Service Establishment Bill 2025, Nigerian Tax Bill 2025, Nigerian Tax Bill 2025. In conclusion, the committee wish to thank Mr. President of the Senate and Chairman of the National Assembly. We also want to thank the leadership of the Senate, members of the committee, and all for all the contributions. For the first time, this committee had a retreat with over 62 senators in attendance. And all the days, we have never had anything less than 46 sitting. That shows you the importance of this. We thank the staffs of the Secretariat who works assiduously to ensure the timely completion of this report. I so submit, Mr. President.
Thank you, distinguished Chairman of the Senate Committee on Finance. I also want to thank senators who collected the bills and went home and studied overnight. And during our closed session, they made very useful contributions. So it's very clear now that the entirety of the laws are embedded in our, and we are ready to go into action. Is there anybody who would like to make comments before call on the no comment? The Senate Leader, you may now move that we go into closed session into Committee of the Whole to consider
Mr. President,
the report clause by clause.
okay. Mr. President.
Oh, no, please. Let me give Senator Alero the opportunity, Senator Yaya, rather, the opportunity to report on the Elders Council and their intervention. When the bills came, they generated a lot of furor. So the Senate, in its wisdom, had to set up the wisest of its men to go into the bills, study, and bring out areas of possible conflicts for the benefit of all Nigerians. And at the end of submitted their report to Committee Finance for deliberation. And I want to know whether they are well captured, and we are now ready to pass the submissions, all encompassing, for the benefit of Nigerians now and in the future. Senator Yaya, our leader.
Thank you, Mr. President. My highly respected and distinguished colleagues, I am Yaya Abdullahi representing Kebbi North. Mr. President, you recall that at its plenary held on 3rd December 2024, the Senate set up an ad hoc committee to interface with the executive arm of government, including the Attorney General of the Federation, with a view to resolve the issues that arose in the course of legislative processing of the Tax Reform Bills 2024. The Senate will recall that in the wake of Mr. President's submission of the bill to the legislature in October 2024, some political and revenue sharing controversies. In the opinion of the Senate, these need to be understood and resolved before legislative consideration and processing of the bills progress beyond second reading. The members of the committee, I hope members have the copy of the report. Paragraph 2, the methodology that we adopted is there in paragraph 3, which included interaction with the General of Federation, Permanent Secretary, Ministry of Justice, Executive Chairman, Federal Revenue Service, Executive Chairman, Revenue Mobilization, Allocation and Fiscal Commission, chairman of the Presidential Committee on Fiscal Policy and Tax Reforms, and also the chairman of the Federal Inland Revenue. This provided opportunity for face-to-face discussions on the controversial issues that were contained in the bills. So paragraph 4, we presented our findings and recommendations on the on all the on all the issues, and this included harmonization of multiple taxes to a few that are simple and broad-based, unification of the revenue collection function, modernization and simplification of revenue administration, leveraging on the use of digital technology, the use of data and intelligence to curb evasion, and removing tax provisions that are inimical to business and economic growth. These are of the reform bills. Now, we presented the bills, the 4 bills that were considered, and we made recommendations. Now, like I remarked, and also Senator Eleru and the chairman of the ad hoc committee, Abbo Moro, also looked at, we made our recommendations regarding each of the bills, which you can see from page 4, page 5, page 6, and identifying the various areas that we think need reconsideration or need concern of this distinguished chamber. Now, in the process of having all of us, most of us actually being members of the Committee on Finance, we very closely interacted with the chairman of the Committee on Finance. In fact, during the consideration of all the meetings that we had with the Committee on Finance to consider these bills, the chairman of the committee and his deputy, who is one of our leader, deputy minority leader, we were very close together, so that whatever issues that we found in these issues of concern, we took them close by close and advised the committee, the finance committee, to look at those issues and take decisions. And all these issues that we have listed from page 4 to the end of the document have all been discussed and thrashed out, and recommendations came out and were approved at the meetings of the committee. Therefore, from what we have here and what is contained in the bill, I am reliably informing this distinguished Senate and Your Excellency, the President of the Senate, that all these issues, as far as the areas why we zeroed the areas of concern, have actually been addressed, and we didn't take the decision ourselves. We presented and argued at the meeting of the committee that took a decision on these issues one way or the other. Therefore, as far as we are concerned, as the members of the committee, a lot of the issues that we thought are quite controversial and those who nearly became centers or areas of controversy have been brought before the committee and thrashed to the satisfaction with this, and to satisfaction, and actually amicably resolved at the committee meeting. Therefore, what the chairman is bringing now is a comprehensive that states the position that democratically arrived at the meeting of the Committee on Finance. But that does not, like I said earlier, preclude senators now from making observations if we go close by close. If there are areas of contention that the Senate needs to look at the time when we come for the consideration of close by close, senators may bring those issues up so that a decision will be taken one way or the other. I thank you very much, Mr. President, for giving the committee, the ad hoc committee, and including myself, the opportunity of the Senate, and bring this report, formally at plenary. I thank you, Mr. President.
Thank you, distinguished Senator. Yeah, what it really means is that what is worth doing is worth doing well. From your report, independently, the elders took into account the contentious areas and then summarized them and presented to the main finance committee, and they have all now been incorporated. So we can say to a large extent, over 95%, that we go with the tax bills. It still does not stop any senator from raising any issue on any clause as we proceed. But I want to thank you and thank all our members. In fact, particularly the distinguished senators for their patriotism. I was thinking that Senator Wadada just came in now fresh. He should give us an opportunity to continue the discussion. Senator Wadada, you just arrived, right? Thank you for the opportunity of not disrupting the session. So I want to say I'm happy with the processes that we have taken. And this is, like I said, we are doing this for Nigeria. Some of these laws date back to 1901, before 1950, some before 1960, and they were never reviewed. And some have become very anachronistic. The Stamp Duties Act, some of them were in the 1930s. So now that we are bringing this, harmonizing them, reviewing them to meet with modern realities, I believe Australians should be happy that yes, they have a very responsible Senate, they have a responsible National Assembly. Even as we proceed today, if areas, we will set up a conference committee to meet with the House of Representatives and ensure that everything is smoothing before we present to Mr. President for asset. Deputy Senate President.
Thank you, Mr. President. Mr. President, I stand to congratulate the entire Senate, and in particular the Committee on Finance and the Elders Committee for the wisdom and leadership that have been exhibited so far in dealing with these bills. Initially, there were, disagreements. There were disagreements. There were rancors here and there. But the Senate, in its position as the highest assembly in the land, decided to establish this committee of elders, to look at all those areas of contention. Look at all of them and hear the views of leaders, regional organizations, and what have you. Excuse me. To look at all these issues. Now, thank God, the committee also in its wisdom had a very robust public hearing and got to where we are now. And thank God all these areas have been, resolved. That's why this is the beauty of democracy. This is the beauty of democracy. And I'm proud to be a member of the Senate for the maturity exhibited in dealing with this matter. Now today, we are all on the same pedestal, agreed on this issue. Religious leaders and everybody, all those, NGOs and what have you, Governors Forum and the rest. And now we're on the same page. The same page. I congratulate all of us, particularly the Elders Committee. You've done a wonderful job. We are proud of you. And Mr. President, we're also proud of you, proud of the leadership for exhibiting the wisdom to set up this committee in the first place. So now we are going to deal with the clause by clause. We are going to the clause by clause stage of looking at the bill. And I'm sure there won't be any rancor because we are all on the same page.
Only one correction from what you said. It wasn't you don't call it. It was a special committee of the Senate.
So a special committee.
Because there are people that are, otherwise if you say Elders Committee, Elders Committee, Senator Fadahonsi will ask you, am I not an elder?
Sorry, I withdraw that. Okay, that's your...
It's a special committee.
I withdraw that.
Special committee.
A special committee.
Special committee of the Senate.
Special committee. Yes. So I withdraw that. Special committee.
Thank you.
So you've done us proud. We are proud of you. And I congratulate everybody. Thank you, Mr. President.
Leader of the Senate.
Mr. Senate President, I stand to move a motion that we resolve into Committee of Whole to consider this report clause by clause. I so move.
Yes, the minority leader.
Colleagues, I write to second the motion that we resolve to Committee of Whole to consider clause by clause of the bill. I so second.
Distinguished colleagues, having heard the exhaustive synopsis summary, special committee as well as the committee on finance, a motion has now been moved that we now resolve into committee of the whole to consider the reform bills for Nigeria clause by clause. Those in support of this motion say aye.
Aye.
Those against say nay. The ayes have it. We resolve it to committee of the whole.
So this money is separate.
Thank you. Distinguished colleagues, Nigeria Revenue Service Establishment Bill 2025, SB 584. Those in support of the long title on page 1 say aye. Those against say nay. The ayes have it. Those in support of the 43 clauses in the bill say aye. Those against say nay. The 43 clauses. Don't worry. Let's leave out the clauses. Let's go into clause by clause. Okay, so I take clauses 1 to 10. Any objection? Well, you have any objection in clauses 1 to 5? Anybody? Those in support of clauses 1 to 5 say aye. Those against say nay. The ayes have it. Clauses 6 to 10. Those in support of 6 to 10 say aye. Those against say nay. The ayes have it. Clauses 11 to 20. Those in support of clauses 11 to 20 say aye. Those against say nay. The ayes have it. Clauses 21 to 30. No, distinguished Senator Tambua.
Mr. Wait. You sent it in. Adiola, Yai, your prayer is not answered. Mr. President, sitting as chair, I have an observation on clause 22, fund of the service. There is established for the service a fund which has consist of and to which shall be credited A, 3% of the total revenue collected by the service which may be appropriated by the National Assembly subject to review as the economic situation may require. Mr. President, I have concern about appropriation being may. We shall appropriate, not may. Mr. President, I so observe.
Any seconder? Yeah, so many hands. The Dismissed Senator Olamilego. So many hands.
Thank you very much, Mr. President, Mr. Chairman, President as Chair, Adiola Solomon Olamilekan. I rise to second the motion as moved by Senator Aminu Tambo. I so second. That the word be changed from may to shall.
Okay, so read the particular clause. Is it clause 22A?
22A.
2A. A percentage.
That a percentage shall be determined by the National Assembly of the total revenue collected by the service, which shall be appropriated by the Assembly for capital and recurrent expenditure of the service.
Okay, the correction is like this. A percentage as may be determined by the National Assembly of the total revenue collected by which shall.
Yeah, shall.
Because the operative word in contention is may, which shall be appropriated by the National Assembly for the capital and recurrent expenditures of the service. So in other words, that percentage, huh? Okay, this is now. So the look at the middle. What you have there is down. Recommendation is 22A in the middle. 3% of the total revenue collected by the service, which here it says may be appropriated, but we are changing it to shall be appropriated by the National Assembly, subject to review as the economic situation may require. In other words, the review is not the appropriation, the review is a percentage. Is a percentage that shall be, but it is the appropriation or appropriating the percentage shall be compulsory. But right now, 3% may be reviewed from time to time, depending on the economic situation of the country. But the appropriation shall become, it doesn't matter what percentage, whether it is reviewed to 1, whether it is reviewed to 2 or reviewed to 5. But whatever is reviewed shall be appropriated by the National Assembly. Those in support, The what, man?
Subject to the review of the percentage So let's put the percentage after the review of the percentage.
Your Excellency.
Is the entire clause that is subject to review from time to time. Subject to the review of the percentage. The subject matter is the percentage.
Yes.
That's what I'm talking about.
Because of a.
Yes. So what you are saying is that this one seems to say 3% simplicity. No. We are saying
Now
we are not
subject to review.
No, we are
not talking so that nobody will come tomorrow and say, "Oh, you are talking about the review of the entire clause." Subject of the review of the percentage.
Okay, so redraft it. Let us see.
Yes.
Redraft what you are saying.
Yes.
Redraft it. Read the whole sentence. Use your mic.
3% of the total revenue collected by the service, which shall be appropriated by the National Assembly, subject to the review of the percentage as the economic situation may require. Well, the legal department can.
On the same subject, sir.
Yes. What the distinguished colleagues, please, what the DSP is proposing. Senator Warada, you just came now. Allow those who were here to talk. If you have the understanding, go ahead and contribute.
Thank you very much, Mr. President. Distinguished colleagues, on the same item A, mine is on the percentage. 1% is the most acceptable and implementable or implemented. Excuse me, I have the floor. Would you listen to me to the end? Jimo Ibrahim, this is not capital market. Shut up and behave.
I know.
I apologize.
Distinguished Senator Jimo Ibrahim. Distinguished Senator Jimo Ibrahim. Even the use of the language, Warada knows that he was about to face punishment. So I'm sure he's going to apologize.
I apologize.
Warada.
I sincerely do.
No, withdraw the language and then apologize.
I said I apologize.
No, I didn't say what you said. I said withdraw.
It is withdrawn, but next time don't interfere that way.
Okay. So
it is
withdrawal and apology hereby accepted.
What I was saying, Mr. President, is that 1% is the international accepted.
No, sorry, we are not redrafting the bill. We are doing clause by clause constitution. So listen to this. What is recommended by all is that 3% of the total revenue collected by the service, which we have now corrected to shall, which shall be appropriated by the National Assembly, because here what they had was may. In other words, they can spend the 3% without appropriation. But we are now saying shall. Shall is
Yes.
compulsory, which shall be appropriated by the National Assembly, subject to the review of the percentage from time to time, depending on the situation or as the economic situation.
What I'm saying is ours should be since
And note, what is currently being collected is 4%. So they say
but oil is inclusive. Oil is inclusive. That's why I am saying ours channel for now should be 2%. 2% instead of
okay. Though you are this Senator Wadada, this is Senator Wadada. Look at your order paper, your standing Senate standing orders, 2023 as amended. Open to order 84-2. Open to 84-2. And please read. 84-2. No, use your microphone.
84.2, no amendment shall be moved which is inconsistent with any code already agreed upon or any decision already come to by the committee, and the chairman may at any time during the discussion of a proposed amendment withdraw it from the consideration of the committee if in his opinion the discussion shall have shown that the amendment violates the provisions of this rule. So then we
So
must
what it means is that the committee had agreed on the 3%. And so no further amendment can be carried out.
So why are you changing may to shall? That's it. That's it.
I'm sorry.
Yeah. We are contradicting ourselves then.
Senator Wadada, this is Senator Wadada. I am changing Shah to and moving May because I was here before you. So I'm more conversant with the subject matter. And then if you wish to proceed further than where the rule tells you, come by way of motion so that we will debate it here and then we will agree. So your objection is ruled out of order. Those in support that 3% of the total revenue collected by the service shall be appropriated by the National Assembly. Senator Wadada, approach the chair. So, any seconder to the proposed amendment that we of the word shall and present? Yes, Senator Wadada.
Thank you very much, Mr. President, distinguished colleagues. This time, I am not on the may or shall order. I mean, words. What I am.
But you are still on section 22.
Yeah, the same on the same section. But what I have is, I will want us to invoke section 1B of our standing orders of the Senate 2023 as amended.
Read section 1B.
Now 1B.
Hmm?
1B says, in all cases in this standing order or by seasonal or other orders or practice of the Senate shall by resolution regulate its procedures. And by this, I am calling on the President to allow me propose an amendment from 3% to 2% because the subject matter is all encompassing. It involves both oil and non-oil revenue. What will be accrued to the coffers will be more than the budget of 15, 16, 17 states of the Federation. So for that, let's reduce it to 2%.
Any seconder? Yes, Senator Hanga.
Mr. President, I second the motion for amendment of this section, ably moved by my brother, Senator Odada. I so second.
Distinguished colleagues, two legs. The first is those in favor that we utilize the section 1B of our standing rules in order to allow for amendment of the proposal here, say aye. Those against say nay. The ayes have it. The second leg is that the motion has been proposed and seconded, that we review the percentage from 3% to 2% in view of the fact that the entirety of the revenue are now consolidated, both oil and non-oil. Those in support that we review from 3% to 2% say aye. Aye. Those against say nay. The ayes have it. So we proceed. 2% of the total revenue by the service, which shall be appropriated by the National Assembly subject to the review of the percentages as the economic situation may require. Those in support of this amendment say aye. Aye. Say nay. Yes. So we are clauses 11, no, clauses 21 to 30 as amended. Those in support say aye. Aye. Those against say nay. The ayes have it. Clause. Yes.
Mr. President, we discussed this on the question of either executive chairman, executive vice chairman, or managing director. So I think we should note wherever we come across this, when we say executive director, we are talking about the executive vice chairman.
So propose.
Sir, what I'm saying
Which,
is,
which clause?
30.
Okay.
Yes,
We are on clause 30.
So I'm saying
yes.
we should not, that wherever we come across this executive chairman, it is.
Chairman of Finance, I thought you should be very interested in what we are doing here.
The deputy leader is the one obstructing me here, sir.
What is your opinion on clause 30? He's saying that where we have executive chairman, we should change it to executive vice chairman in order to allow for.
I think it's a typo. There's an error for.
Well, that's why I say let us not.
So
let us not.
So read, please use your mic.
Clause 30, accountability, I think is from the typing. It's supposed to be the executive vice chairman of the service shall.
So why don't you just move a motion?
Sir?
That why don't you move a blanket motion? That wherever we see executive chairman, we should refer to it as executive vice chairman. So that we take a mutandis.
Sir, so long.
Your mic.
So long as it is for the executives, because we have chairman of the board, we have executive vice chairman, who are in the executive, and this one is on the board. So wherever we see executive chairman, we should be executive vice chairman. That's what I'm saying. So if we can move a motion,
you can move the motion that wherever we see executive, and the next word that follows is chairman, that it should actually be changed to executive vice chairman.
Exactly, sir.
Because the board will eventually have a chairman.
Yes, sir.
Mr. President, let me make one clarification. Anywhere you see executive chairman as existing here is the way the bill was before the amendment. If you look at our recommendations and you look at the interpretation and the definition, okay, I will want to move a motion that anywhere you see chairman should be changed to anywhere you see executive chairman should be changed to executive vice chairman. And that is only in the recommendation part. Motandi. Thank you, Your Excellency.
Come for legal tutorial.
Thank you, Your Excellency.
Motandis.
Is it Motandis?
Well, Senator
Motandis Motanda.
Yes, but it's still good to, you see, it is better to err on the part of surplusage. As I speak, it is already in the interpretation clause. But there's nothing wrong in putting it here, because otherwise we cause confusion. So, Jim Ibrahim, you may wish to second that motion that wherever we see the word executive and chairman follows should actually be executive vice chairman. And Mutati. Press for your mic. Oh, it's not your seat. No, it's not. No. No, it's committee of the whole.
Without this word. Mr. Senate, Mr. Jimo Ibrahim, representing Ondo South from Ondo State, do rise to support the motion ably moved by the committee chairman of finance, that's Senator Sani Musa, that wherever we see the ward chairman should lead the ward vice chairman accordingly. Thank you, Mr. Chairman.
Distinguished colleagues, the motion has been moved and seconded that wherever you see the word executive and chairman follows that, you should correct it to vice. So it becomes executive vice chairman. Those in support of the motion that will run mutatis mutandis across the entirety of the bill, say aye. Those against say nay. The ayes have it. And this will go through all the bills. So the Senator Anga, your concern has been taken care of. Thank you. So we now look at clauses 31 to 41.
Yes.
Yes, Senator.
Yes, sir.
Senator Mongunu.
31.3. Mr. President, distinguished senators, my name is Mohamed Tahir Monguno. I represent Borno North Senatorial District. What my concern is the that in any legal proceeding under this bill or any of the laws authorized by the service, any act or thing done by the service or the board, the laws referred to in sub-clause 2 shall not be subject to challenge on the ground that such act or thing done was not proved to be in accordance with the given by the minister.
Don't go there. It already shows that whoever inserted this clause is planning to fight with the minister.
Yes, and it borders on Oster clause.
Yes,
and we are not in the military government where we host the jurisdiction of
we can do that.
the courts.
We cannot.
It's draconian and obnoxious.
It's draconian, obnoxious, and self-serving.
Yes, sir. So we should expunge that aspect of the provision.
Those in support that we expunge that provision say aye. Those against say nay. The ayes have it. This provision infringes on the fundamental human rights of individuals. You cannot oust the jurisdiction of the court. Neither can you oust somebody from challenging an action undertaken by anybody, and you cannot use the law to deem that action to be a representation of the approval of a minister, whether the minister approves or not. It doesn't make sense. So that is why it's important we look at these things. Come there, clerk. Did you get it? It's totally obnoxious. So 31.3 is hereby deleted.
I just, because I overheard the chairman of the finance committee suggesting that we are retaining what is contained in the original provision. But that's not the case. The case is that the entirety of it is gone.
Gone.
Thank you, sir.
Yes.
Thank you, Mr. President. On general directions of the minister, miscellaneous provisions.
What clause?
Clause 31.1. Here it says, the minister may, after consultation with the executive chairman, give written directions to the service on general policy matters, and the service shall comply with such directions. So this is obnoxious. There is a board of directors who are supposed to formulate policies for the board. There's a chairman, non-executive directors and executive directors who are supposed to formulate policies.
We don't have executive chairman any longer.
No.
That is why here it says in consultation with executive chairman. And what we have is executive vice chairman.
But how can the minister give him directives on policy matters? I think the right thing is for the board to take a decision, and then if there's any controversy beyond the board, then the minister is informed, and the minister maybe takes it to the council. But if the minister should go and act as the executive chairman, because he's like acting as an executive chairman, in any organization where there's management, there is a board. The board and members of directors of the board are the people that formulate policies.
No, you see, in this case, the minister is in charge of both fiscal and monetary policies. And that's why even currently we call it coordinating minister of the economy. So the minister can, from time to time, give directives on policy, on general policy direction to the board. And can also give directive to management through the executive vice chairman. It's true. He said the minister shall not give any directive, any direction in respect of any particular person, which would have the effect of requiring to increase or decrease any assessment of tax made or to be made, or any relief given or to be given, or to defer the collection of any tax or judgment debt due. They has already restricted the minister. Yeah, it has restricted the minister, so I think the only thing we need to do there is just to put the word executive vice chairman. I hope the chairman of finance, you have to tidy this document in line with the amendments being made here now for the benefit of the secretariat. The secretariat will also try its best, but you who understands it more should take sure that you tidy it, and then copies must be resubmitted to all distinguished senators. Is that the view of the Senate? Those in support say aye. Those against say nay. The ayes have it. So these things will be taken care of, because the word executive vice chairman has changed the nomenclature, has changed everything that was. So we take it that 31 to 41 is carried. Those in support of the the Senator Dan Kwambo, former Accountant General of the Federation.
Thank you, Mr. Chairman. Section 39, sir. I support that we keep the existing section instead of the amended. A warrant issued by the executive vice chairman, approved by the minister, is also subjected to another approval by the National Assembly. That will cause a lot of delay, and that will not have any effect on the finances. So we retain the existing section.
Well, again, the word there is executive chairman, and what we have approved is executive vice chairman.
Mr. President, anywhere you see executive chairman, that was the proposed bill, so we now gave recommendation and changed it from executive chairman to executive vice chairman. So anywhere you see on that column, that is what you will continue to see, because that is the original proposal that came. And we have done the amendment.
Mr. Chairman, what we are saying is that it should not be approved by a committee of the National Assembly.
How can you have oversighting powers over an appropriation you have made? You said you are taking away.
Your mic.
Mr. President, what I'm saying, to clarify this, the reason why we put the National Assembly is because we are giving a new authority to minister based on the recommendation from the executive vice chairman to the minister that accountant general can deduct directly from MDAs. So we said, since it is budgeted from the appropriation, we will also want that to come back to the National Assembly, because anything that has been appropriated, we are oversighting it. So how do we know? By the time you see, the agency will tell you they were not able to do anything because their money had been taken. So what do you do about that? If there's any solution, we will adopt it.
Mr. President. Thank you, sir. Mr. President, I rise to support the observation of the former Attorney Federation. Today we are in the National Assembly. What is certain is that tomorrow we will not be here, but this institution will be here. But in all our conversation earlier, we emphasized the need to leave this business in the affairs of competent, qualified people. We are trying to divorce the system from politics as much as possible. Now, when this has gone through all the relevant agencies, manned by people who are competent as provided for under the law, with profound respect, I do not think that the fact that National Assembly has oversight responsibility, that we should now become an approving authority. No, let me finish. Therefore, I agree absolutely with the sentiment expressed by Senator Dakwambo. I think that what should give us comfort is the fact that, stated or not, anything done by anyone spending or appropriating public funds, this National Assembly has a natural oversight responsibility. That does not mean we should be consulted first before certain things are done, so that we avoid delays such that may turn out to hurt all of us. So that's why I think that Dakwabo, given his background, is being a Accountant General of the Federation, and he understands the issues, and in all of this, time is of the essence. Whatever is delayed today might become damaging to it. I just
Distinguished Senator Oshimole, in practice, no, sit down. In practice, what Senator Dan Kwambo is saying is that it would lead to a lot of bottlenecks. That where the minister has given a warrant to the executive vice chairman to go ahead and deduct money from agencies and all that, that's an executive function. And to subject that to the approval of the committee of the Senate means even to deny the Senate and the House of Representatives the opportunity to undertake the oversight. It's going to take long, because it's not only the committee of the Senate that will be required, it will be National Assembly. And so to subject it to National Assembly, that is House of Representatives and the Senate, the process will become nebulous and cumbersome. So I think we should Distinguished Chairman, you should.
I concur.
Yeah,
I agree
absolutely with that Kwabo's position.
He's about to agree with you.
I agree with your explanation, Mr. President. But I want to put it also here on record that it is not people that are novice that have worked on this. When Mr. Distinguished Senator Oshomole is making his remark, he said it's always good to give to competent people. I'm a professional. I'm in the field also, financial. So I know what I am doing. So if it is referred that for those that have done this, we have looked at it carefully. And the area that we were only trying to protect is a situation where any budgeted, any fund that has been appropriated by the National Assembly to an agency cannot just be taken. That is all. Senate, in their wisdom, feel this is the right thing, so be it.
The difference in what you are saying is that it is the same administration. I don't think they will go and just take money from an agency without reason. We have all been chief executives one way or the other. So there may be constraint. For instance, you may be under pressure to settle a judgment debt. And the only way you can do it to avoid your properties being forfeited is to take money from anywhere you can see it immediately. Outside that, you have to go for loan. So if that is done, it's left to us to go and oversight and find out whether they can return the money or they cannot return the money. What was the deduction used for? You understand? I don't done out of context of probity and accountability. So, but if we have to approve that action, we're going to move in circle. So I think we should go with Dan Kwambo. Distinguished Senator Dan Kwambo. Distinguished Senator Dan Kwambo. Now formally move a motion for the amendment of that section. Move a motion for the amendment of that section.
Okay, sir. Your Excellency, I, Senator Kwambo, do hereby move that Section 39 be retained as it is. I so moved.
Read what you want us to retain.
The Accountant General of the Federation shall, not later than 30 days of receiving a endorsed by the Executive Vice Chairman of the service and approved by a judicial officer in accordance with the third schedule of the bill, deduct a remitted revenue due from any ministry, department, agency, or government from its budgetary allocation or such other money accruing to it, and shall remit the deductions to the service.
In other words, the new recommendation is rejected.
Yes.
Yes, yes, Distinguished Senator Oshimole.
Mr. President, Adams Oshimole, I represent the people of Edo North. I rise to second the amendment as proposed by distinguished Senator Dakwam.
Distinguished colleagues, the motion has been moved and seconded that the Senate do retain the original provisions of Section 39 and reject the proposed amendment. Those in support that we retain the original provisions say aye. Aye. Those against say nay. The ayes have it. Section 40, 41. Those in support say aye. Aye. Those against say nay. The ayes have it. Interpretation clause 42, which is on page 40, Those in support say aye. Those against say nay. The ayes have it. Short title, clause 43. Those in support say aye. Those against say nay. The ayes have it. Schedules 1 to 3 on pages 43 to 48. Those in support say aye. Those against say nay. The ayes have it. So I thank the chairman of the committee on finance and my distinguished colleagues for the painstaking manner in which we have approved the Nigeria Revenue Service Supplement Bill 2025 as amended. Distinguished colleagues, we now look at the second bill. We are still in very serious. The Nigeria Tax Administration Bill 2025. A bill to enact, please correct that part. A bill. Distinguished colleagues, a bill for an act to provide for the assessment of collection of and accounting for revenue accruing to the Federation, the federal government, the states and local governments, and thereafter prescribe the powers and functions of tax authorities and for related matters, SB 585. So Nigeria Tax Administration Bill 2025 SB 585. We have looked through. So clauses 1 to, yes. Let's start with Senator.
Mr. President, Chair, my colleagues, starting from the long title of the bill, an act to provide for the assessment, collection of, and accounting for revenue accruing to the Federation, federal, states, and local governments, prescribe the powers and functions of tax authorities and for related matters, SB 585. Mr. President, I have a very serious concern, particularly when you go deeper into the provisions of this particular bill at clauses 87 downwards, where it is clearly intended that we make laws for states and local governments. This is against the Constitution. We don't have powers to make laws for states and local governments. So we may, Mr. President, go into this and look at it more dispassionately.
What section tells you that we don't have powers to make laws for states and local governments? Because what I know legally by the Constitution is that any law that is enacted by a state or a bylaw by the local government, which is inconsistent with an act of parliament, at the national level is null and void to the extent of that inconsistency.
Mr. President, you don't make laws for states. That's why you have state houses of assembly.
No, we do. We do. We make laws for states. Where the states make laws, and there's an act of parliament where you have an exclusive legislative list, then you have the concurrent legislative list. Where there is concurrent legislative list, in other words, the state can make law, and the federal government can also make law on the same subject matter. The one that is made by the federal government, that is the National Assembly, the one done by the state, if there is inconsistency, the one by the federal government stands, and the one done by the state is immediately null and void to the extent of that inconsistency.
Well, I stand to be corrected, Mr. President.
Yes.
I maintain my position.
Okay.
Mr. Chairman, I would like to inform the former governor and the former speaker, that this particular provisions that the governor was trying to cut took about 3 days. In fact, we had to stand it down. I invite reputable legal minds in this country. And of course, the SAN, our own, was there, and this matter was discussed. And that it was agreed in total that we can do legislation for Nigeria, which includes the subnationals. So I'm not sure whether, I don't know the problem that Senator Tambo has on this part, in regard to this particular aspect. Also, you recall that we sat here and do ICPC and do EFCC, and said was not comfortable, and they took this matter to court. And the Supreme Court said, no, the National Assembly has powers to do those, regardless of the subnationals. So I think we are comfortable here, unless there are other legal minds that will say constitutionally we cannot. But the court, the Supreme Court said we can, and I think we should.
I wish you had also consulted, because I would have also been paid consultation fee as a ranking legal mind. I from my head alone, I know that we can make laws that will bind the states and local governments. If there are areas we cannot, the Constitution will separate those areas. But on areas of there are exceptions. On areas of jurisdiction, Leader. Yes, sir.
Thank you, Mr. President. Adini Adegwami Odo Central. With respect to what His Excellency Senator Tabua said, I think we need to go to the second schedule of the Constitution, which is the exclusive legislative list. Subsection 59 is clear. It says, taxation of incomes, profits, capital gains, except as otherwise prescribed by this Constitution.
Please start again.
I said that with respect to what Senator Tabua has said, the powers of the National Assembly are stated in the second schedule, part inclusive legislative list. And subsection 59 says we have powers to make laws for taxation of incomes, profit, gains, except otherwise prescribed by this Constitution. We need to understand that what we are doing here is a bill for taxation. If we go to the latter part of the bill, we debated it, as Senator Nigi said, where we were trying to create state revenue services. We said we couldn't do so, but we expunged those sections and kept the one that deals with taxation, administration of taxation, which is what this bill deals with. Respect to Senator Tabua, I think is wrong to say that we don't have the powers.
Mr. President, please.
I know we have the powers.
Mr. President, please.
Yeah?
Mr. President, point of order, and Constitutional point of order. Section 162 of the Constitution. With your permission, Mr. President, I read. The Federation shall maintain a special account to be called the Federation account, into which shall be paid all revenue collected by the government of the Federation, except the proceeds from the personal income tax of the personnel of the armed forces of the Nigerian Police Force, the Ministry of Foreign Affairs, or Department of Government charged with the responsibility for foreign affairs, and the residents of the Federal Capital Territory. So, Mr. President, the exception on this is that we cannot make law for the collection of revenue on these categories of taxes. Residents of the city, members.
You're listening.
Yes, sir. Okay. Yes. You are not part of the Federation account, but you can collect them because they belong to the federal government or
Mr. President, what I'm saying is that these taxes cannot make law for the collection of taxes mentioned in this section because they belong to FCT and even pay as you earn. We cannot make law for the collection of pay as you earn. It's entirely the responsibility of the State Internal Revenue Service. Thank you.
Thank you. That doesn't need argument. So, please, Senator Jaribe, let's make progress. When we get to that particular section, you can say something. Okay? So, clause 1, those in support of clause 1, those against say there. The ayes have it. Clause 2 to clause 15. Those in support of clause 2 to 15 say aye. Those against say nay. Ayes have it. Clause 16 to 30. Please look out for the sections you are not comfortable with. Look out for it. So as we are progressing, you raise it. 16 to 30. Those in support of clauses 16 to 30 say aye. Those against say nay. The ayes have it. And recall that Senator Sani Musa, this is your biz. We are dealing with. You are not hearing me. So where we have executive chairman, we should also refer to it as executive vice chairman, because we are set mutandis, mutatis. Leader, am I right? Mutatis, a live bencher. Mutatis. But Senator Ashiru said we should speak English. And stop. He's an architect. His mistakes are normally there for all to see. We can use English and cover our own. Okay. So, clauses 31 to 45. Those in support of clauses 31 to 45 say aye. Those against say nay. The ayes have it. Clauses 46 to 60. Yes.
Thank you, Mr. President. Henry Siraki Dixon, Bayelsa West. Mr. President, I'm making
an observation concerning a provision that was debated seriously and agreed upon at the committee level, which is to the effect that a provision be clearly made to authorize the payment of tax revenues, payee and any other taxable revenue for oil companies who are working in various sections of the creeks in oil facilities scattered across various parts of the country. Because currently, the position is that those taxable revenues every month and paid to the state that houses the headquarters. And we agreed. I have been running up and down, conferring with my distinguished chairman of this committee. So may we have clearer direction, Mr. President, as to where that provision or clause is, because I can't find it. And if it is not there, then this is an opportunity for us to insert it after section, so that we can put a clause that in the case of computation of oil, the tax deductible and payable by all sector workers operating outside their headquarters, that those tax revenues be computed and paid to the states where the facilities are domiciled. So I seek that clarification, Mr. President. Thank you.
It's been dealt with on the computation of pay as you earn. It will be paid by the worker where he works. It is not that you go and work in Borno and then your headquarters is in Sokoto, or even a construction worker. You are doing work in Borno, you are resident in Borno, and then you go and pay tax to Sokoto. No.
Observation.
It's been dealt with. It's payee.
Observation.
It was in the past.
Observation,
That was
sir.
in the past. Now, under this,
Mr. Senate President, can I reply that? Can I reply that, sir? Mr. Senate, I want to reply that. I want to reply to
yes,
Senator DCO.
Please answer.
I want to make a reply. Now we have the state inland revenue service.
No, I'll be recognized. It's not a war matter. Thank you, sir. Mr. President, sir. But two things we have to discover, we have to reflect on. We can't make two sets of laws on pay as you earn. There are people working in FCT, but they live in Nasarawa State. There are people who work in Lagos, Mr. President, and they live in Ogun State. The logic of pay as you earn, my brother, is that you pay based on your residence, not where your office is. Because it is in your residence that your family, your children will attend public schools, and it is provided by state government. The purpose of tax is to address the social needs of human beings. And so, if you tamper with this,
use your mic. Use your mic.
sir?
Your mic was not working.
Oh, I'm so sorry. Thank you, Mr. President. I'm saying the taxation is based on your residence, and there are good reasons for it. You spend 8 hours at work, you spend 16 hours outside work. Oftentimes, your children attend schools where you are resident. That is where you drink your water. That is where you benefit from all kinds of social facilities that state governments or federal government is supposed to provide. So, my dear brother, I understand your concern, I understand your pain that somebody flies to somewhere, make money, work there, and then you fly to another place. Unfortunately, we can't make two laws, one for oil workers and one for other non-oil workers.
Thank you.
Your place of residence is the basis for taxation, and it is the state in which you reside that collects the money. Because sorry, I think something is wrong with this microphone system. One is talking, the thing will just go up by itself.
The microphone just goes off. Anyhow. Which sensor? Let the sensor arise.
So thank you, sir.
Mr. Senate President, I think you gave me the floor to make my own contribution.
Senator Jimmy, debating.
No, it's not a debate. It's a clarification because some of us also saw the tax or taxation. The issue here raised by Senator Dixon.
So let's go to the clause.
There is nothing offending in this bill because of the State Inland Revenue Service. They are to find out where the residents is and they go there and collect the tax. It is not it's okay the way it is.
Let me explain.
And it's that is no, the argument does not offend this very bill as it is.
We are on clause by clause consideration.
Yes, I'm making contribution
when
to
Senator Tamboa mentioned, he was saying that we should not make laws generally for local government taxation and state taxation. And then the senator, you can't be arguing here. You should have been arguing in meetings. So chairman, you should have argued with him in your committee meeting, and you should have invited him to come to your committee meeting now. Now I'm trying to explain that you have answered. Sorry, I'm coming. He has answered this question in section 87 by showing that the Joint Revenue Service cannot make laws for the collection of state taxes, and so this act provides for creation of state service by the states. It's already there. So the states will create their own revenue service. And so it is not the federal government that will collect taxes for states. So that answers your question. It's there. They have made that recommendation. So when we go there, we put it properly for better understanding. And what you were saying was a situation whereby somebody is working in your state and paying tax in another state. We must correct it because it has been part of the agitations that the Niger Delta people have been complaining about. Yes.
Point of order. Mr. President, Order 84. With your permission, I read. Procedure on bill in the Committee of the Whole of the Senate. The chairman of the committee shall call the number of each clause in succession, or the first and the last number of a group of clauses, and if no amendment be offered thereto, or when all proposed amendments shall have been disposed of, shall proceed to put the question that the clause or the clause as amended stand part of the bill. Mr. President, as we know, we all know this. Mr. Chairman, sorry, we all know this process. You will be calling clause by clause, we're going clause by clause. If anybody has an amendment, such person will raise up his hand, and the chairman will now allow him to move that amendment, and the question will be put. So it's not time for debate. It's tomorrow. It's a procedure. Mr. Chairman, please guide the Senate so that we follow the normal procedure. Mr. Chairman.
You have the DSP, you have just given guidance to the Senate. So why do you say guide the Senate? Your point of order is sustained. I had mentioned clauses 46 to 60. Those in support say aye. Those against say nay. The ayes have it. Now I know you are tired. So clauses 61 to 75. Those in support say aye. Those against say nay. The ayes have it. Clauses 76 to 90.
Chairman.
Yes. I'm sure you are coming to 87.
Yes, sir. Mr. Chairman, I am back on the issue I earlier raised about whether we can make laws on certain matters for the state house, for the state government. Clause 87 is talking about establishment internal revenue service.
It's an observation. Sorry. I observed that all the people that are going to consult with the chairman of finance were all members of the finance on this bill. So this is the time that he should be listening to us. If there is an amendment, you go and reflect it. But not the time for you to consult with members of your committee. But if all members of your committee are coming to you, you wouldn't have time to listen to the observations of the Senate. Please continue.
Thank you very much, Mr. Chairman. I was trying to attention to clauses 87, 89, up to clause 93, whether we can establish state internal revenue services for states with their functions, with their management, structures for state revenue services. Can we, under the Constitution, Mr. Chairman, I have my concern?
We cannot. Yes.
I don't know how these particular clauses actually came up. We had a very robust debate of this matter. These particular clauses were actually expunged. They were expunged.
Okay. So please move a motion, Senator.
Well, Mr. Chairman,
before we do that,
no, use your. It's my candid opinion that we cannot create state revenue service because we have houses of assemblies.
We all agree.
Huh?
But no.
We are taking over the jobs of state houses of assemblies. And when they have crisis, but right now they don't have crisis. By Section 11 of the Constitution, it gives us the power to take over the functions of the houses of assemblies where they are unable to do so. But right now, we don't have that situation. A law here closing the ability of the houses.
Let's look at the content, sir, before we throw it out.
No, the question is, can you make laws?
It's not a question of making law. Read what it says. Mr. Chairman, let's read the content of what is in this. Let's read the content. That section says that without prejudice of the state government with respect to administration of income tax of individuals pay as you earn, stamp duties, each state may establish a state internal revenue service. That's what it says.
They have already.
Superfluous. Yes, you can say that it's superfluous, but yes. I mean, it's not on the powers of the state.
So those in support of the proposition that states should be allowed to create their own revenue service, as recommended in Section 87, say aye. Those against say nay. The ayes have it. So the entirety of those provisions allow the National Assembly to make to create state revenue service. Those provisions are hereby expunged. And Senator Tambua, move a motion and mention the areas that should be expunged.
Mr. Chairman, my distinguished colleagues, having been established that it would be superfluous for us to pass these provisions as contained in clauses 87, 88, 89, 90, 91, 92, 93, 94, 95, 96, 97, 98, 99, and 99. I hereby move that all of these be expunged from the bill.
Any seconder? Yeah, this is Senator Mweboye.
Mr. President, I rise to second the motion, praying inter alia to expunge from section 87 from 7 to 98 of the bill, sir. I so second.
Well, we are in terms of correction, it should be 98, because I think section 99 is about creation of executive chairman.
Yes. Okay, yes, yes.
Which we have to discuss.
Yes, Excellency.
So the motion has been moved and seconded that we expunge from clauses 87 all the way to clause 98. Those in support that those areas be expunged, say aye. Those against, say nay. The ayes have it. So 87 to 98 hereby expunged. Look at clause 99. No, just clause 99. Clause 99 says executive chairman. The powers and duties which are conferred on the executive chairman of the relevant tax authority by this bill and other tax laws exercised by the executive chairman or by such other persons authorized to exercise such power. Is there anybody who may wish, chairman, you want to move a motion that this be changed from executive chairman to executive vice chairman to exercise the powers of all the tax bills? It was there, but it's important for clarity. I'm saying it's better to err on the part of surplusage. Section 99.
Mr. President, my distinguished colleagues, I stand to move wherever we see executive chairman from section 99 and onward should be changed to executive vice chairman.
Thank you. Distinguished Senator Odende.
Thank you, Mr. President. My name is Emmanuel Memga Udende. I represent Benue Northeast. I stand to second the motion as ably moved by Chairman Finance Committee. I so second.
Distinguished colleagues, the section 99 has been amended to, instead of executive chairman, it says vice chairman mutatis mutandis. Those in support that will proceed with we approve section 99 as amended, say aye. Those against, say nay. The ayes have it. Section 100 to 102. Those in support of clauses 100 to 102, say aye. Those against, say nay. The ayes have it. Yes, distinguished Senator Dan Kwambo.
Thank you, Chairman. Section 80, sir. The amendment we made in the previous one should also be applicable to this section 80.
That's why we use the word mutatis. In fact, this we must stop this mutatis mutandis, because there was a particular law we made here. When they got to the House of Reps, it was changed, and that had to do with the development commissions. So that was in respect of Southwest. So they were putting 3% on fuel, 3% on depot, 3% on port authority, 3% on this. So we said we don't want to touch the the finances of the federation or that of the president. So we should just allow only one source of financing. But we use the word mutatis mutandis. So unfortunately, some of the development commissions were still looking at mineral resources, gold reserve. so without using that word, mutatis mutandis. So your observation is sustained.
Section 99 also affect the states, and I don't think that clause should also remain here. We passed that, but we need to be very careful so that we don't do something that because it says so. It says, may I read, sir? Executive chairman and other officials of the relevant tax authority. The powers
of the relevant
tax authority. The powers and duties which are conferred chairman of the relevant person authorized to exercise such powers. I think it still also affect the states.
How? Did they mention states?
Well,
tax board bill, which we're going to also consider. So if
it's talking about the generality of the bills.
It should remain.
It should remain. Section clause. Which clause? Which clause?
It's clause 81. It's so important that I want to take a second look at it. Because that's the section. I'm sorry, it's important that we talk about it. The whole day when issues were introduced had a lot to do with this section. Mr. President or Chairman, this is the section that talks about distribution of VAT revenue. All the debates we have in this country goes up to the center of this. I'm not opposed. It's one. Thank you. I'm using my mic. Thank you. So, Mr. Chairman and my dear colleagues, I think there's need for us to take a second and careful look at this provision. We are pleased with the consultations that were done at different levels, and there is a proposal that appears to enjoy some level of support, which we can work with at least for now. At least for now. But what I don't understand, Mr. Chairman, is why there is reference, if you look at it down, after stating equality, the indices, population and VAT, then you now go to local governments, and there is talk 70%, and then population 30%. I don't see that. I don't quite understand why we have to, in a law, stipulate what the local government should do with the monies that they get. I thought that once we legislate the broad terms of distribution of VAT, that is okay for us. Not to go down to determine what they do and where they how do they apply it based on we are creating confusion. That's my worry. So we need to understand it properly. If there is sufficient basis that will not create crisis,
no,
we can. But I think as it is, it will create a lot of crisis.
Your observation is noted, but you need to know that the VAT is a federal tax. All we are talking about shall be distributed up to the local government level. In fact, if we had our way, we would have said it should be distributed up to every household in Nigeria. That is why this distribution is listed. It has nothing to do with you don't just you don't give money to a local government, VAT from federal government without telling them what to do with it. Otherwise, they can use it for training and retraining of their staff without using it for development. That is why this distribution is important. So the objection is noted, but rejected.
Before we please proceed from that clause 81, just a typo, but very fundamental. Page 85, last paragraph. For the purpose of distributing VAT revenue among the states, place of consumption means the location of the consumer at the point of supply, no off.
At the
Off.
point?
No, just off, of supply. At the point of
It's
supply,
typo.
OF. Just that.
Noted.
Please, thank you.
The clerk, please make that correction.
There's a difference between point of supply and then point of consumption. And
Yes.
VAT is a consumption tax.
You're right.
And it is based on consumption.
So
whatever we are doing, so it should be point of consumption.
Move a motion to change it from supply to consumption.
Yes.
Huh? Go ahead.
I want to a little bit draw caution before we go ahead and consider the position of my brother. And I want you to analyze what they want. Because the basis of sharing this, which is one of the major issues of this bill, this is where we are. If it's at the point of consumption, okay, no problem. You are right, no problem. Yes.
VAT is a consumption tax now.
The chairman,
it's just like sales of goods.
Chairman, Committee on Finance, please move a motion for us to amend what is here now. No, let the chairman move. Chairman, move it from point of supply to point of consumption. Chairman, proceed.
Three. Yes, Mr. President, my distinguished colleagues, we have defined what VAT is. We said VAT is a consumption tax. And we all agreed that VAT will be shared based on consumption. So I want to move a motion here because it's something that the even Forum of Governors agreed on this. I want to move a motion for the purposes of distributing VAT revenue among the states. Place of consumption means the location of the consumer at the point of consumption and not supply. Yeah, that is what is in the interpretation.
Henry Seraki Dixon, Bayelsa West. I rise to heartily second the motion that has been so ably moved by my able chairman.
Distinguished colleagues, those in support of the motion say aye. Those against say nay. The ayes have it. So we change it from point of supply to point of consumption. So clauses 91 to 105 as amended. Those in support say aye. Those against say nay. The ayes have it. Clauses 106 to 120. Those in agreement say aye. Those against say nay. The ayes have it. Clauses 121 to 135. Those in agreement say aye. Those against say nay. The ayes have it. Clauses 136 to 148. Those in support say aye.
Aye.
Those against say nay. The ayes have it. Okay. No, your mic came on. I wanted to. No, your mic keeps coming up and now. Clark, please check because they are saying censor. Censor should off the mic. You shouldn't on the mic. Interpretation clause 149. Those in support say aye. Those against say nay. The ayes have it. Short title clause 150. Those in support that it remains part of the bill.
So, with your permission, draw our attention, because what is worth doing is worth doing well. 147, I have some concerns. Mr. Chairman, I have some concerns. Because even at our committee levels and even at the advisory committee that you and the leadership graciously empaneled, this was one of the issues we drew the attention of the framers of this legislation. Because this section is trying to cloak this bill with a level of constitutional infallibility. It says that any law that conflicts with this is null and void. It's only the Constitution that has because that inherent status in our hierarchy of laws. This is a legislation like any other legislation. That it is a taxation bill does not mean we should elevate it to enjoy the same status of a constitution, of the ground norm. So I'm not convinced that this section 147 adds even to the bill, because whether it is there or not, if there is a challenge, the courts will do their work. So I humbly move that we, with all due respect, expunge it in its totality. I so move.
Yes.
Mr. Chairman.
Exactly.
Mr. Chairman.
I didn't get what Senator Dixon said very well. Senator Dixon. Huh? One. Senator Dixon, move a motion to expunge section 147 because the Constitution takes precedence.
Yes, exactly. Thank you, Mr. Chairman. Mr. Chairman and my distinguished colleagues, by unanimous agreement and by your permission, may I move that section 147 be expunged. I so move.
Yes, Senator Tambua.
Mr. Chairman, my colleagues, I rise to second the motion as moved by Senator Dixon that section 147 be expunged.
What is the chairman of finance? Chairman of finance. A motion has been moved and seconded that Section 147 is in conflict with the Nigerian Constitution. That it says, the Nigerian Constitution says that every law made that conflicts with the provisions of the Constitution is null and void. The committee actually says so. The remark of the committee says so. The remark of the committee says so. So those in support that this section be expunged say aye. Those against say nay. The ayes have it. It's already there. It's already there. You did the right thing. The committee did the right thing. But why did they repeat it if it's already it before bringing it back to us? You understand? It was already not necessary to put it back inside the bill, since you realized it was in conflict with the Constitution. And anyway, interpretation clause 149. Those in support say aye. Those against say nay. The ayes have it. Short title clause 150. Those in support aye. Those against say nay. The ayes have it. Schedules 1 to 5. Those in support say aye. Those against say nay. The ayes have it.
Point of order, sir.
Will the Senate approve the Nigerian Revenue Establishment Bill as amended? Those in support say aye. Those against say nay.
Point of order, sir.
The ayes have it. Will the Senate approve the bill to provide for the assessment, collection, accounting for revenue accruing to the Federation, federal, states, and local governments, and prescribe powers and functions of tax authorities and for related matters, SB 585. Those in support that this bill be approved as amended say aye. Those against say nay. So for the tax, the ayes have it. The Nigerian Tax Administration Bill, the Nigerian Revenue Service Establishment Bill, both are hereby approved. Let me thank the committee chairman and members and thank the entire Senate for painstakingly going through this clause by clause to ensure that what we pass is left for posterity to enjoy and to avoid conflict in lawmaking. I want to also state clearly that if there is any provision that we have missed out, it will be corrected by the judiciary if anybody challenges it. We can't do both the work and the work of the legislature. Just to call attention to my parting words, it is the work of Parliament to enact laws. It is the work of the judiciary to interpret the laws. So let us not sit down here after we have finished enacting a clause or enacting the law. We now try to interpret it. Then we are taking over the job of the judiciary. So I want to thank you for the approval, and I want the Senate leader to now move that we revert to plenary to report progress.
Mr. President, sitting as chair, very distinguished senators of the Federal Republic of Nigeria, I rise to move that the Senate now reverts to plenary to enable the chairman report progress. I so move.
Yes, the minority leader.
Thank you, Mr. President. I so second.
The motion has been moved and seconded that we move from the committee of the whole to plenary for the chair to report progress. Those in support of the motion say aye. Those against say nay. The ayes have it. From the way Senator Ningi is looking for progress, it means he's feeling guilty that he has not been reporting progress. Distinguished colleagues, the Senate in the Committee of the Whole considered the report of the Committee on Finance on the Nigeria Tax Administration Bill 2025 and approve as follows. Long title as recommended. Number of clauses 1 to 79 as recommended. 80 to 81 as recommended. As amended, rather. 80 to 81 as amended. 82 to 86 as recommended. 88 as deleted. 99 as amended. Clauses 100 to 146 as recommended. Clause 147 as deleted. Clause 148 as recommended. Interpretation clause 149 as recommended. Short title clause 150 as recommended. Schedules 1 to 5 as recommended. Is this a true reflection of what transpired in the Committee of the Whole? Distinguished colleagues, we go to the second bill. The Senate in the Committee of the Whole considered the report of the Committee on Finance on the Nigeria Revenue Service Establishment Bill 2025 and approved as follows. Long title as recommended. Clauses 1 to 21 as recommended. Clause 22 as amended. Clauses 23 to 30 as recommended. Clause 31 as amended. Clauses 32 to 38 as recommended. Clause 39 as amended. Clause 41 as recommended. Interpretation clause 42 as recommended. Short title clause 43 as recommended. Schedules 1 to 3 as recommended. Is this a true reflection of what transpired in the Committee of the Whole? Leader of the Senate. You may wish to move a motion that the two tax reform bills be now read the third time.
Thank you, Mr. President, and very distinguished colleagues. I rise to move that the bill be now read the third time. I so move, Mr. President.
The two bills.
The two bills be now read the third time. I so move.
I hereby invite the clerk of the Senate. No, the minority leader, you need to second this motion. Yeah.
Thank you, Mr. President.
Yes.
Distinguished colleagues, I'd like to second the motion that the two bills be now read the third time.
Distinguished colleagues, the minority leader has seconded the motion that the two bills be now read the third time. Those in support say aye. Those against say nay. The ayes have it. Clerk of the Senate, proceed.
Mr. President, distinguished senators, I bill for an act to repeal the Federal Inland Revenue Service Establishment Act number 13, 2007, and enact the Nigeria Revenue Service Establishment Act to establish the Nigeria Revenue Service, charged with powers of assessment, collection of, and accounting for revenue accruable to the government of the Federation and for related 25, third reading. Mr. President, distinguished senators, a bill for an act to provide for the assessment, collection of, and accounting for revenue accruing to the Federation, federal, states, and local governments, prescribe the powers and functions of tax authorities, and for related matters 2025, third reading.
A bill for an act to establish the Joint Revenue Board, the Tax Appeal Tribunal. No. I take that again. Distinguished colleagues, a bill for an act to repeal the Federal Inland Revenue Services Establishment Act by 13 of 2007 and enact the Nigeria Revenue Service Establishment Act to establish the Nigeria Revenue Service charged with powers of assessment, collection of, and accounting for revenue accruing to the government of the Federation and for related matters 2025, third reading taken. Distinguished colleagues, a bill for an act to provide for the assessment, collection of, and accounting for revenue accruing to the Federal Republic of Nigeria, the states and local governments, prescribe the powers and functions of tax authorities and for related matters, third reading taken. Distinguished colleagues, a bill for an act to repeal the Federal Inland Revenue Service Establishment Act number 13, 2007, and then enact the Nigeria Revenue Service Establishment Act to establish the Nigeria Revenue Service charged with the powers of assessment, collection of, and accounting for revenue accruing to the government of the Federation and for related matters 2025, third reading taken and passed. Distinguished colleagues, a bill for an act to provide for the assessment, collection of, and accounting for revenue accruing to the Federation, federal, states, and local governments, prescribe the powers and functions of tax and for related matters 2025, third reading taken and passed. Let me thank the chairman and members of the Finance Committee, committees, including the consultants and also the elders special committee of the Senate and all distinguished senators that worked on these two bills that have now passed third reading. And also pray that these bills will revolutionize tax collection distribution in Nigeria. I thank your patriotic zeal and determination that from morning till past 5 in the evening, you have sacrificed so much to ensure that you dot the I's and cross the T's and amend where necessary to have a document that can withstand the test of time and work for the whole Nigeria. Today, you have dispelled rumors that these tax reform bills were meant to save any section of Nigeria or any group of persons. You have shown that these tax reform bills are actually meant for the collective good of all Nigerians to reform our tax administration, tax collection, tax distribution, and add value to governance in Nigeria. So I thank all of you, and I pray that God Almighty will take you back safely and protect you. Can we say amen? Now, for tomorrow, the production votes and proceedings for these two bills will take time. And then, of course, we also expect that we will complete the other two outstanding bills tomorrow. And we will go through the same process. Even if we have to stay till 10 p.m., we must make sure that what is worth doing is done well. We will start, we adjourn because of the need to produce the votes and proceedings. Those have to be ready for you. So they have to work throughout the night, and it's extremely voluminous. And the paperwork, so we'll be starting tomorrow by 12 noon. We will not start very early because we can come and they are not ready. But clerk of the Senate, do your best to make sure that by 12 noon tomorrow, the votes and proceedings of these two bills are ready. And then we'll take on the rest. So the Senate is accordingly adjourned to the 8th day of May 2025 at 12 noon prompt. Yes, yes. Yes, that is being done now. That is being done right now. As you are stepping out now, you pick the two bills.